To our third day of this very, very extraordinary and fascinating conference. We're going to be in this panel looking at the law and reality of the right to work. The right to work is a complex and interesting right in itself. It relates to obviously certain foundational interests that we have in activity and work, but exactly what constitutes work? What are the possibilities for its realization? It's complex economically to guarantee such a right, so what exactly are the obligations that the right imposes? And of course then one of the interesting things that this project has looked at, which we'll hear more about, is this intersection between labor law and the right to work, and considerations between the fundamental rights framework and labor law. So I think we are in for a panel, and of course also one of the great strengths that we've seen in this conference is also rooting it very strongly in the empirical realities of India and engaging with the questions in that context. So we're looking forward to, we have a fantastic panel over here. As with the previous panels, you've got the biographies in your booklet, so that we won't do introductions, and we have quite a lengthy panel, so we're going to get started. And to present the work of the project and some of the findings, I'm going to hand over to Ms. Nikita Agarwal.
Good morning. So I was sitting with some of the ASTI workers when they were laid off on a very, very random basis, unceremoniously, without no in the factory for participating in the unionizing activities. Now, all these workers were contract workers that we're talking about, and the workers went on a huge protest, and it was a long hunger strike. And what was very interesting to me during that strike was that a lot of women workers were actively participating in the dharna, and staying out late at night and camping in the protest site, which was something that had not happened in the area of Manesar before, an area in Haryana which is extremely conservative. Now, in conversation with the workers, I very naively asked them about the changes. Where is the... I asked them about what they thought about the changes in the Delhi-Mumbai Industrial Corridor laws. I mean, the laws that were changing in Rajasthan and Gujarat specifically, which were effectively diluting labor legislation. Some of the amendments, to give you very briefly, was the one was a change in the Factories Act, where the threshold limit of applicability of the Factories Act, so what would be deemed as a factory as defined by the number of workmen in the factory, was reduced. Then there was a certain reduced responsibility of the employer as well as the principal employer. Now, Section 2 of the Industrial Disputes Act includes the principal employer within the definition of the employer, and the amendment effectively removed the principal employer from that definition. Also making the right to unionizing more strict by increasing the number of percentage of workers who would have to sign an application to get a trade union registered, and other such amendments which effectively diluted labor legislation within the Delhi-Mumbai Industrial Corridor. It was a clear move by the governments in order to facilitate higher flexibility of the labor market within that area in order to cater to the demands of the Delhi-Mumbai Industrial Corridor. Now, while I was talking to them, what they told me, and I felt incredibly naive after that, was that Okay. Labor laws are redundant. It doesn't really matter what amendments to the labor laws are really happening, because in Hindi it was told to me कि हमें क्या फर्क पड़ता है क्या कानून है, क्योंकि कानून तो हम पे अप्लाई ही नहीं करता है. So I felt very naive, especially because I did have some idea of the Maruti struggle and the long struggle, and also how had been witness to how the laws had constantly failed the workers in their struggle to unionize. Now, when you look at the Maruti story of unionization, and in my case study I've done other parts of the struggle of unionization is also intertwined with the kind of working conditions and the increased contractualization and then subsequent casualization of workforce. But I'm only going to be dealing with the story of the unionization in order to keep up with the time limit. So the story of the unionization is one which is viciously anti-union. It demonstrates that the state was completely hand in glove with the management, and the judiciary in many ways was also more concerned about attracting foreign investors and foreign investments within the area, and did not allow for bail and other give pro-labor judgments, and the management was more interested in establishing dummy unions, welfare and committees, works and grievance redressal committees, which would do everything which was more general matters and would not engage in anything, would not collectively bargain with the workers. Now, the story of the Maruti workers is a struggle of unionizing is a long one. So just to quickly get into the story, there are four stories, there are four phases of the workers' union. Just to point out that the Maruti Union, Kamgar Union, was the first union. It was a union set up in December 2000. It was set up by the management. It was a yellow union, and apart from representing the union, representing the workers in dioceses and garlanding very important persons, the MUKU did nothing of any kind of representation and negotiations with the management. Now, there were no elections that were also held of the MUKU. The first election that was held was in the year 2011, which was in the wake of the Maruti Suzuki Employees Union, an application which was filed by the workers in the Labour Court in Chandigarh in June 2011 for the purpose of 11 workers had signed it, 11 representatives had signed the application, and it was to register an independent trade union, which was a workers' union. Now, after the filing of the union, application for the union, the very next day, when the workers reached the Maruti plant, they were asked to sign undertakings showing their allegiance to the MUKU. So the Labour Court had informed the management about the said application, and immediately the management went on the offensive. After that, there were 3 very long and very significant strikes that happened between June and August 2011, where there were a lot of negotiations that happened with the management and the MSEU, but the union did not get registered, and the Labour Department rejected the application twice on technical grounds. So after the MSEU, after the third strike, when the Labour Department rejected the application, the Maruti Suzuki Workers Union was formed, which was subsequently registered because of the long struggle of the MSEU. The management had promised that they will allow for the registration of a union, and which did finally get formed. and in January 2012, it submitted a charter of demands to the union, to the management, but there was no legibility that was given to the MSW by the management, which refused to negotiate with the workers, with the union. So after 10 to 12 negotiations that happened, the talks broke down because the management was more interested in setting up a works and grievance redressal committee, which would look into wage and quote-unquote other general matters. Now, there was just one small strike that happened with the MSW, which happened, I mean, a lot. I'm assuming that a lot of people within this room are aware of the 19th July incident where Jia Lal was a worker was abused in a casteist manner, and then the subsequent fire broke out, and the HR, who was also a pro-worker person, Avanish Dev, was killed. The workers say that he was suffocated. The management says they were killed, and the management eventually fired 546 permanent workers and 2,300 contract workers. And 147 workers were, including, of course, the entire union body, was put in jail in several charges. One of them was culpable homicide amounting to murder. Now, after that, the workers find themselves in a very difficult spot. Their entire union body is in jail. A lot of the workers are in jail. Some of them are out of work. Some of them are still in the plant. So what do? They form a proto-union with the provisional committee coming into play, which takes on the union body work and also takes on the struggle to release the workers who are imprisoned by the imprisoned. Now, during this entire process, I'll just finish. The workers' union, the provisional committee was given a lot of legibility and did in many ways fight elections by way of representations and by presenting their own panel, which won with a sweeping majority, and entered into further negotiations with the management, and is still very active in raising the demands of the workers. So I'll just end my presentation with that. My job was to confuse, I confess, more than to clarify, because that's my state of the mind, and I hope that the rest of the panelists will shed more light into the confusions that I have.
Thank you very much for providing us with that starting case study, concrete empirical examination of the issues around unionization that have occurred. And to continue the discussion, I'm going to call Mr. Saurabh Bhattacharjee.
A very good morning to all of you. Nikita's presentation pretty much set out the tone and the context within which labor law operates. And she said her job was to confuse us. And it is indeed a very troubling juncture at which we speak about right to work. Her case studies illustrate the systematic assault on the right to collective bargaining, the broad dilution of labor rights that's taking place. And most troublingly, when workers themselves speak of redundancy of labor law, it requires us to look very closely at the direction that labor law is taking and to what quantum do we find right to work being foregrounded within our discussion of labor law. Before I go into some of the main arguments that we take in our project, I would just like to set out the statutory context or the normative context within which right to work operates. We must acknowledge that our Constitution speaks of right to work within Part 4 of our Constitution. And Part 4 also includes several other rights pertaining to labor and employment. And beyond that, we also must recognize that right to dignified working conditions has been acknowledged as part of right to life within Part 3 of our Constitution as a fundamental right. The question for us is, what do we mean by right to work? And pretty much for every major socio-economic right, one of the foundational questions that comes up is the meaning and the scope and ambit of the right itself. And for that, the International Covenant on Economic, Social and Cultural Rights provide us a very useful framework of identifying the different components of right to work. And General Comment number 18 of the Committee of Economic, Social and Cultural Rights and the General Comment number 23 both elaborate on what we mean by right to work, and they specify how Article 6 speaks of the general dimensions of right to work, but how Article 7 specifically speaks of the right to enjoy just and favorable working conditions. And that goes hand in hand with Article 8, which speaks of right to everyone to form trade union, and that addresses the collective associational dimension of right to work. And I'd also like to draw upon the more recent General Comment number 23, which very emphatically says that right to just and favorable conditions of work is a right of everyone without distinction of any kind. While the comment goes very elaborately into the different components of what constitutes just and favorable conditions of work, but this universality of just and favorable conditions of work provides us a very valuable touchstone to look at labor laws in this country. And in a review, what we found was probably the most perplexing paradox within this discipline, that we have a over-legislated branch of law, and yet workers are severely underprotected. A large section of our workforce falls outside the formal protection of any statutory regime. And we need to question why that has happened, because we have around 60 or so central legislations by certain estimates, and these central legislations are further supplemented by state legislations and state amendments to central legislations, given that large number of labor matters in this country fall within the concurrent list of the 7th schedule of the Constitution, which means both center as well as the state has the power. So we are confronted with a Byzantine maze of legislation, and yet we find a significant section of our workforce outside the ambit of those laws. And why has that happened? And one of the arguments that I'd like to place is that some of our first wave of labor laws were predicated around the Fordian model of production, and in a semi-industrialized country that did not really capture the bulk of our workforce. And that meant that the same model was thereafter tried to be extended to a range of other workers through a patchwork of legislation subsequently. And that has meant that there is a complex network of categorization, and the rights of workers often depend on where exactly do you situate within that categorization. And categorizations are at different levels. And one would believe that given the diverse nature of workforce, the diverse nature of employment relation, perhaps certain degree of categorization is also necessary. But what I would like to emphasize on are three very critical points of exclusion within the design of our labor legislation and labor law as a discipline in this country, which has inherently led to exclusion of significant number of our workers. And I'd like to emphasize very critically on the centrality of relationship of employment. Labor law has emerged around the relationship of employment, and those who work in this field would recognize that the tests of relationship of employment have often been fairly complex. And while courts have tried to relax those standards, and India has been no exception over the last 20-25 years, more prominently Justice Mathew's decision in Silver Jubilee Tailoring House and many other subsequent decisions, which have tried to move away from control and supervision standard of relationship of employment. But regardless of the relative stretching of the definition of employment, the fact remains that a big chunk of self-employed workers, a big chunk of atypical workers who do not fit within this standard model of control and supervision then fall outside the ambit of labor law altogether. And employment only captures one part of workers. Work is much more than employment as such. And yet the centrality of relationship of employment within our discipline has meant that a big section of our workers are excluded, and we need to move beyond this conflation of work and employment, labor and employment. If the right to work means right to just and favorable conditions of work beyond distinction, then we need to move away from the centrality of employment that fits within our discipline. The other point that we need to also acknowledge is several of our legislation are characterized by threshold exemptions, threshold applications, and these clauses include numerical thresholds. So if you happen to work in an establishment which has less than 10 workers, then you may not fall within the Factories Act, no matter what is the nature of work that you do. And then there are several types of threshold clauses which are qualitative in nature. So unless your establishment has been notified by the government, unless your establishment falls within factory, unless your establishment falls within the definition of shops, you may be excluded from almost all the major statutes that exist. And that has meant, again, that many workers fall through the cracks between these legislations, and that explains why we find, in spite of having more than 60 legislation, that almost 90% of our workforce is still considered as part of the unorganized informal sector. The other major finding that we have is even where there are statutory rights, and Nikita's presentation is a great example of that, even where statutory rights are there, the administrative regime that seeks to enforce and operationalize those rights are either distant, and there's a great deal of opacity about which those authorities are, how do we approach those authorities, and even where you approach them, the protracted nature of the proceedings often circumvent the rights of workers. While one would argue, and it's often been argued by employers as well as business press, that the labor litigation and the labor proceedings hurt the employers as well. But given the systemic asymmetry of power between the employer and employees, any such delay, any such sclerotic decision-making by administrative authorities often hurt the workers the most. And even yesterday, during the discussion on right to housing, many of the panelists spoke of how stay order have become a very critical part of exclusion, stay orders without due process. And in labor, we have often found cases where even where favorable decisions have come from the inspectors or from the labor courts, you find subsequently high courts have granted stay. And at the higher judiciary level, we are finding a systematic effort at curtailing some of the remedies that are available to the workers. And all of these have meant that even though we have a fairly impressive number of textual norms that protect workers, there's a huge gulf between the statutory promise and the reality of labor law. The other thing that our study has focused on, given that pedagogy was a big part of this project, was to look at the way in which the discipline of labor law is conceptualized and taught in law schools. And one of the criticisms that we will have is that apart from few exceptions, the dominant way in which labor law has been taught is one of a series of discrete statutory regimes where we focus from one regime to the other. And we tend to ignore the broader political economy, the broader social and the political history behind the emergence of labor law. And often we speak of labor law as a series of managerial issues that have to be addressed. And from that vantage point, right to work or rights at work of workers are ignored, and most of our focus remains on the statutory provisions. Many of our case studies look mainly at the doctrinal developments that take place at the courtrooms and not how they are effectuated at the level of labor commissioner, at the level of the managers, and the enjoyment of rights by those workers in various workplaces. And these are some of the fundamental positions that we have in terms of how labor law is being taught. And if we need to foreground right to work, the point with which we started looking at general comment number 23, that right to just and favorable conditions of work are a right that must be available to all workers without any distinction, then we need to see work as a continuum rather than focusing only on employment. And again, I come back to the point that the notion of employment has been relaxed. but yet that's not adequate. And to that extent, we need to move away from the centrality of employment, and we see work as a continuum from the unpaid household labor to the more systematic supervised labor in an industrial operation. And we must see this as a continuum with different degrees of control, different degrees of formalization, different degrees of supervision and enjoyment of rights by workers. And that also helps us to navigate this so-called divide between the formal and informal sector, where we often tend to see these as two disparate categories. And the other point that I'd like to emphasize on is we must see all the dimensions of work and right to work together. Nikita's presentation spoke of how collective bargaining is being criminalized, how even though we may have a Trade Unions Act, even though we may have a freedom of association, there are almost a concerted attempt by the state to criminalize formation of unions and criminalize any assertion of their rights by workers. If we juxtapose that assault on unionization with statutory norms, it becomes obvious that even those statutory norms that are there on paper cannot really be enjoyed without the representative voice that unions provide. Similarly, without income security, without social security, it's very difficult to speak of rights at work. And one of the things that we found were the workers themselves were unwilling to speak of occupational safety because the fear of unemployment, the fear of job insecurity meant that voicing such concerns was seen as an extremely dangerous move. And in that context, what I'd like to present is the criticality of seeing all the dimensions of right to work together: social security, unionization, and safe and decent conditions of work go hand in hand. And any statutory discipline that is predicated on creation of rights at work, divorced from unionization, divorced from collective bargaining, and divorced from social security, would not really go much far ahead. On that note, I'd like to conclude, and I'm sure there would be several points that would come through from the panel and from your questions. We've also prepared a resource material that we believe can be a tool for teachers in the field of labor law, and I'm sure that's going to be circulated to various participants at some point of time. And we would look forward to receiving comments in order to see to what extent that can be refined and to what extent that can be further sharpened to make it more relevant in terms of reality of labor law and not just as a textual discipline. Thank you.
Thank you very much for that very clear expose of some of the findings of the project. It seems to me that law, we're in love of categories very much in law, and I know the central categorical distinction when we were studying labor law was very much between the employee and the independent contractor, which sort of remains very strongly enforced, but yet, as you've pointed out, there is this continuum of different forms of labor, and are we failing really as lawyers to capture what many, if not even most people are living with in many ways in labor law context today? And I think you've put a strong challenge to us of how do we rethink our labor law frameworks that exist today, and how do we do so in a way that will actually advance protection as well, because obviously when the law intervenes it also brings with it its own challenges in many ways. You also raised the important question of pedagogy and how it is taught, right, and how labor law is taught, and not just as a narrow series of rules, but as part of a complex, what you put, political economy that we need to engage. And that takes us to our next presentation. Professor Kamala Sankaran is going to speak now to us about questions of teaching labor law. Thank you.
Thank you. I thank you very much for that presentation on what the... I hope it's not broken, Amita. I dropped something. On the project, I'll just straight away get on to my comments on what I heard this morning and the brief executive summary of the project that I have heard, it was so interesting to see that one of the key areas was the right to work, which has been focused on. Just one takeaway that I had there, it was interesting that this part of the project is looking at the right to work. Given the kinds of numbers of people that we have in the workforce in India, where more than 50% are self-employed. So I'm not on the taxonomy of organized and unorganized. If you look at India, you find that the number of people who are in paid employment, and even if we were to stretch that boundary of paid employment to include indirectly employed through contractors, even more diffusely employed in other ways, you would still find that the majority of people in India are self-employed. How does the right to work, so if we are addressing the issue that work is a continuum, for a large majority of people, one of the issues that confronts them is their right to livelihood and not just their right to employment. Does labor law and the way it's imagined and the way it is taught, does this address this issue of livelihood? And I'd like to link it to the second point that I want to make. I'll come back to the first just shortly. Of course, a lot of issues, a lot of time has been spent in the academic world about the organized, unorganized, formal and informal. And it's become even more acute in recent times because ILO has declared last year and adopted an instrument saying there should be formalization of the informal. And a lot of the policy decisions of this government in the last 1 year are directed to that. Will the GST result in formalizing the informal? That's been one of the key issues really that we have been discussing last 1 year. Now, if the debate is to shift from formal and informal, and that's the world discourse wants us to shift from formal-informal binary, what do we do with employed and self-employed? What exactly would the right to livelihood entail? And how would it enrich this project in ever so many ways? I just draw your attention to, I think, an absolutely important report, the Arjun Sengupta report of the 2007 National Commission. And you will remember there that there was a draft of a right to livelihood. And that right to livelihood went way beyond employment and work. If I were a street vendor, how will I claim my right to vend on the street? I would be confronting then not what is properly recognized as the domain of labor law, but I would probably be confronting the municipal law, the zoning law, the hygiene law, etc., etc. And I think that that is an issue when we move beyond work to livelihood, employment, and I completely accept what you were saying in your presentation, that there is this continuum. The boundaries of labor law itself have been fixed, I agree with you, either in a Fordist way, imagining that all people who work are in employment relationships, work at the place where the employer works. It's got a real industrial revolution stamp on it. And long ago, I mean, you can look at the work of Otto Kahn Freund, you can look at Sinzheimer, you know that it is completely entwined in the manner in which it arose in the industrialized countries, but which does not have that much resonance in a country like India. I think that it would be very useful that if the world of labor law were to include many other laws where people labor and where the laws impact them. Can the Forest Workers Act be imagined and reimagined as a labor law legislation? Because it is one that where people work, the fisheries, the world of work is so large and there are many laws that impinge on them. So I think one of the first takeaways, I think, as how we imagine it to be taught in law schools or in universities or wherever labor law is taught is to understand that the boundaries of labor law are so fluid and porous, and we should be willing to look well beyond that. Otherwise, a standard labor law 101 is that we have 46 central labor legislations, so many state legislations, blah, 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 and then we have these 3 important labor laws, ID Act, Trade Unions Act, so on and so forth. So I think that reimagining and understanding that livelihood takes you well beyond that. Coming back now to employment itself, the core on which so much theorization has taken place. The employer-employee relationship is, of course, no longer so central. And how do we bring in people who are employed through a contractor? And I think both the studies alluded to it, the Maruti study particularly, because the violence was on the shop floor at Manesar. You have 2 categories of workers, one who earns probably 3 times and whose work, and the other who's so precarious. And the violence and the anger is there, and it's very palpable in any place. The outsourcing is so enormous in India. The latest data is showing that it has spiked in the last 10 years. The number of people who are employed through contractors, even in traditional organized sector, has really increased. How do we bring that and those stories into the classroom? And that brings me to the point that I want to make about how we structure our class, the place of work. How do we bring these stories of people who are unfair exploitation within the classroom? Is it a correct thing for the teacher to be partisan or not? And I think when we are dealing with labor law, it's absolutely correct and fine for a teacher to adopt a stand and be very express and open about it. And this is something that has been debated often. When you are a teacher, what exactly should your role be? Can you take sides? How do you engage in a debate? But I think when one is teaching labor law, I don't know whether the title of that subject itself should change or what. But in any case, for the time being, I'm using the word labor law. That is an issue that I think that we need to discuss. I was also asked that I must speak on the materials that should be done, how these could be modified for teaching this particular subject. And when I was thinking about it, and Professor Bagchi is here, so I'm going to mention one thing. Long ago, in 1985, he was the chair of the 2nd Gujarat Labour Law Review Committee. And in that committee report, Professor Bagchi had talked about the subversion of labor law that goes on a day-to-day basis. Now, that subversion of labor law is something that I think we must bring into the classroom. And the subversion happens in ever so many ways. While the rest of law is universal, you will see that the direction of change in labor law has been highly individualized. As an individual worker, you will go and seek your enforcement of your right. You know, I think one of the questions that has been looked at in this entire project is, what do I mean when I say I have a right? How do I realize that right? And one of the unfortunate things in the way in which labor law has developed in India is that the realization of the right is rarely done in a collective fashion. It's done at an individual level. We don't have collective laissez-faire a la all these other countries. We have states that have produced an enormous amount, legislation which has produced an enormous amount of protective legislation, but it results in the individual worker having to go and enforce that right. It's not done through the collective bargaining process. So it introduces this great vulnerability for the individual worker, which is why there is this whole explosion of case law. If you are a labor law teacher, there are literally lakhs of cases that one will have to grapple with. So in order to make sense of those lakhs of cases, the need to understand an individual worker who navigates the system. I agree. Unfortunately, there are very few ethnographic accounts of how an individual worker navigates that system. But it's only through that one can understand that you can have this right in the form of a protective legislation, but an individual who tries to navigate the system finds it so difficult. So what are the kinds of materials that we can bring into the classroom? Necessarily, we have to go outside the case law method, necessarily, and bring in a whole lot of other materials, which many teachers are doing. But I think in a subject like labor law, all the more necessary, from economics, etc., or from sociology, to see how this is done. I think I should also wind up. Perhaps I'm running out of time. But the other point that I thought really struck me in the study was the Maruti case. The individual struggle of the union workers who struggled. And collective bargaining in India rarely happens. Something like 2% of the Indian workforce is covered by collective bargaining. But at this current point in time, we teach a lot of collective bargaining rules and talk about the fact that it's not being implemented. So if we were to have a course structure that reflects the diversity of the Indian workforce, and I'm not saying equally, but the amount of time spent for people in non-employment relationships, people in self-employment relationships, those in employed relationships, somewhat equitably, that would help. However, the real, if you could use this expression, the vanguard of the workers who are leading the struggle are coming from the organized sector. So necessarily one has to spend a little more time dealing with these issues. The conflict between selective rights and universal rights that happens all the time in labor law is another aspect that we need to really discuss with. I was a little uncomfortable, I must tell you, with this right to work. Right against whom? Is it against the state? If it is against the state, then are we demanding full employment? And we know that that's never been the case. It's always, in wherever it has been raised, it has been diluted to a form of public assistance, social insurance, social security. So are we talking about a right to social security? Is that the way we want the right to work? I think that's another issue that I would like to flag. And if it is against the employer, then it is job security for the person who is in employment. So is that the quality of the right to work? So that phrase, right to work, to me has been a little problematic. But I think that when we look at it in a larger context, what it probably tries to capture is the rights at work, the rights at livelihood, and the right to obtain a meaningful form of livelihood or work. Because whom this right is going to be agitated against is a little unclear. Forgive me if I did not understand the concept note correctly, but that to me was something that we need to look at. So when if the project is going to be looking at the indeterminacy of the right, the exactitude of the right, case studies that will explain how a person who is in formal employment enjoys job security vis-a-vis somebody who is in contractual employment enjoys that job security. Somebody who's an outsourced or an outworker enjoys this. Somebody who is in self-employment, how they ensure it, I think would give you a range of people in the labor market and the kinds of reality that they confront every day. Okay, I think I'll stop here. Thank you.
Thank you very much for posing, I think, some of the challenges of an expanding subject, whose range can include general socio-economic rights around livelihood, etc., to the various different types of work, to the very contours, as you raised at the end, of what is meant by the right to work as well. And obviously the challenges within a course, how does one cover it all? But I think the challenge is actually to expand beyond some of the existing constraints in some ways of the ways in which courses are taught. And we also have a further presenter on this, Professor Vasanthi, who's going to take this a little bit further and also talk more about this question of teaching labor law.
Good morning, and I must begin by thanking all the presenters from yesterday who kind of engaged with questions of rights, socio-economic rights, and what it means for a large section of the marginalized to help us also formulate one particular section of the marginalized, which is persons who are categorized within this broad category of labor. And there are so many questions that one needs to engage with, whether one wants to talk about how it is taught or how does one conceptualize it, these distinctions between work, livelihood. There are so many questions, but since I don't have so much time, I'm going to talk about only two aspects of this larger context, borrowing from what we've been hearing in the last 2 days. The first perspective that I really thought was useful, which we can use here, is the question of understanding rights as moral rights, not necessarily looking at it in terms of how it is realized, how statutes look at it, but to recognize rights in terms of the fact that every individual, though of course I disagree with Professor David on whether it moves beyond human beings to other sentient creatures, I am very much talking in terms of the understanding of human rights and the idea that when we talk about rights, what we're talking about is the entitlement of a person to be treated equally with the other. And that, I think, is particularly relevant in the context of labor law, rather than look at the actual realization of how much, who enjoys that right, to what extent. That could differ. But the recognition that there is a right that needs to be engaged with, I think, is a very important aspect. So if we use this approach towards labor, and the other interesting perspective that I thought was useful for me also was to look at fundamental rights as bridges. And I thought that is again the concept that, sure, we're recognizing rights and we recognize this gulf between what we say is normatively available and what is actually available on the field. Where do constitutional rights or where do fundamental rights actually play a role in this? And the idea of then using rights as a bridge to reach, for the norm to reach the reality, I thought was a very interesting concept. And let me illustrate how I think this is important for labor. If we talk about labor rights, and then we get into this debate about civil, political, socio-economic, labor rights were the precursors of human rights in that sense, and they looked at rights as indivisible. For labor, the question of collective bargaining is an amalgamation of socio-economic and civil political. The right that you assert yourself and the right of what we understand as self-recognition is in the sense that I will decide what the extent of my right is. That particular right that is contained in collective bargaining, which is not about entering into a bargain with the employer. It is about being able to set the terms of engagement. And that is an extremely political right, but it carries with it the idea that you're trying to reach some goals in terms of a wage, in terms of leave, in terms of the very small things that people want, but it is emerging from the right that I will decide the terms of engagement. And so collective bargaining can't really be captured in any singular legislation, though of course we do make miserable efforts at it, and that's where I would want to point out to Saurabh and Nikita that the statute also doesn't recognize the right to collective bargaining. We have a ridiculous statute that doesn't recognize any rights. There is no right to trade unions. There is no right to collective bargaining. We kind of assume that the legislations that we have are also geared towards rights, but unfortunately our legislations are not really geared towards rights. So the gap that we're looking at is not just in terms of statute and realization. The gap that we're also looking at is what is the right that we're talking about and what is it that the statute actually is providing for. And that is a gap that as lawyers is something that we should try to bring in front of students. So when we say, for example, equality, and we use the language of rights, when we say equality and we suddenly say, okay, what does equality mean for a person? It's not in terms just of equal wages, but when we're saying equality of recognition, we're also saying what is the meaning of equality when women continue to bear an unequal share of unpaid work? How does that equality translate when we're talking about labor law? So when we say that women enter into the labor force on par with men, and we know for a fact that they don't enter on par with men. They are burdened with so many other aspects which the law simply refuses to engage with. So the language of rights then allows us to open up spaces within statute that perhaps would not exist otherwise. So the recognition of unpaid work, and the point that Professor Kamala was also making, the recognition of work in other forms. So when you start talking about unpaid work, and you start talking about care work, for example, and you find that that does not figure in the realm of labor, notwithstanding the manner in which you're expanding on rights, it continues to be an area where you don't see a recognition of care work, whether paid or unpaid. And what does this mean for labor? And how does the right to equality then play out in the context of these is something that I think allows us to look at both labor law and its realization very differently. The language of rights also allows us to move beyond these boundaries of formal, informal, private, and public, because as far as some aspects of work are concerned, all of these are equally exclusive. Nobody recognizes the right, the work that is done by persons. Nobody talks about, and I suppose we were talking yesterday about the idea that the family then subsidizes for the state in a major way, and this is the hidden welfare state. Now, how do we allow this to come into the realm of law is something I thought that the language of rights could be useful there. The other aspect where when we talk about labor and we talk about constitutional and we talk about other rights together is the advantage that then you're also not only able to open up constitutional law for spaces which otherwise did not exist, you're also opening up labor law for spaces which otherwise did not exist. So the reference to livelihood also comes from the recognition of self-employment, which is largely the mode by which women engage in livelihoods. So the recognition of other forms of work other than the paid work, other than the 9-to-5, other than the industrialized work, happened when we began to open up these spaces and start looking at other forms of work. And although the flexible work has become the norm, and you do see an increasing feminization of labor, at the same time it has brought in challenges which existing frameworks simply are unable to even begin to engage with. So the reorganization of labor law that is required is required on many fronts. It's required on the way in which we are understanding and defining work. So even yesterday we said, is it important for us to have definitions even if they're vague? Sure, but the fact remains that the definition needs to be challenged seriously. When we say work, when we say livelihood, when we say employment, and we are attaching so many entitlements to them, what happens to people who don't find themselves within these categories? So when we say, okay, unpaid work can't be recognized as work, what happens to entitlements which then need to attach with this form of work? What happens to people who are not able to market the work that they are doing, and what happens to entitlements for them? So I think we do see an attempt that this is being done, like when we said social protection, one of the agendas that the ILO is pushing is social protection, or is talking about income protection. I think we are moving beyond work and employment in very significant ways. And that is a challenge to labor law, that if we are going to move beyond the understanding of paid employment, and we're beginning to recognize unpaid work as well, and we're beginning to acknowledge that there are entitlements which have traditionally been associated with work, but now we need to move them beyond people who are in formal or informal employment to other persons as well. How is this actually going to play out, and what are the rights that we will need to recognize when we're doing this? So I thought just these two ideas of using the rights framework, but not the rights framework as a solution, and that's why I thought the Bridges idea was very, very useful. Because what we have seen traditionally, and the reason I believe for the number of labor legislation is that the state kind of uses legislation as a way of saying, okay, you have a problem and I have a solution and we fix this and it's over. So we make a statute on contract labor and we said we've addressed the contract labor issue. So when legislation also comes in as a way of, in that sense, taking away the political aspects of a struggle, or trying to co-opt a particular idea into itself, the state becoming, and the Industrial Disputes Act, I've always taught my students that the Industrial Disputes Act shows the state as this largest union. The state in India always wanted to be the biggest dada there. It said that no, everybody else is small in front of me. I'm the one who gets to refer disputes. I'm the one who will solve your problems. Don't go to anybody else, come to me. So it is that never really got challenged. No, this idea that the state would then become the provider. Of course, it was done with very good intentions, I'm sure. But we all know what happens with good intentions. So this was intended that the state become this big provider. But when the state then begins to violate its premise, then how do we then articulate this need for other forms of organization? And I'll just leave it at that. I hope I'm taking on from Nikita and further confusing everybody here, and so there won't be too many questions for me. Thank you so much.
No, I think you did not confuse us. You added a very important perspective on these issues. And I think one of the things for me was very interesting is it's not just about the existing statutes and the relationship with implementation, which is itself problematic, and we saw from sort of a case study, but also the very definition of norms in this area, right? And how do we define what is desirable in some sense and what it is that we want to be realized? And I think you've put on the table very importantly this question of how do we bring in various other forms of equal recognition into this area. So from the realm of teaching, and I want to say that for the discussion, that's one big area that we need to have for the discussion, is how should it be taught? And so perhaps people who are teaching labor law or teaching other areas of law want to kind of formulate their questions around some of the challenges that have been posed. And I think there's a question there of balance as well. How much do we engage with the kind of approaches that are suggested in the report versus the traditional components of the statutes, etc., which also are very important as well. So we're going to need to think about that quite carefully. And I think I want to just say that that's one area for the discussion going on. We're now moving to the practitioners, right? And Professor Mihir Desai, who's been in the trenches of the courts, I want to hand over to you to give us your perspective. Thank you.
At the outset, I must thank Amita and her entire team for organizing such an excellent interaction. Thank you. My vicarious guru, Professor Bagchi, and friends. In the high courts and in the Supreme Court in India, especially when there are more than one judge sitting on a bench, the first judge gives a judgment, one of the judges gives a judgment, and the second judge or the third judge or the fourth judge just writes a sentence saying, I agree. And that's the end of it. I feel tempted to do so. If it was a 5-judge bench, then with Nikita, with Saurabh, with Professor Kamala and Vasanthi, and if I was the 5th judge, I would have just said I agree and sat down. But since I'm not a judge and I'm a lawyer, I never miss a chance to speak, so I'll utilize this opportunity. I will be focusing on employment law and some of my experiences as a litigator in the traditionally what is known as employment law or labor law. When I started practicing about 30 years back, that was in labor courts in Bombay and Thane. Those courts were vivacious, vibrant. You could see hundreds of workers, unionists, coming, litigating, fighting, struggling, and on issues such as Charter of Demands, the collective bargaining process, on issues such as justifiability of a strike, etc., etc. And now when I go to those courts, they are extremely dull and completely non-vibrant places. You have very few cases. You have virtually no cases dealing with collective bargaining, charter of demands, etc. You have virtually no cases dealing with strikes. By and large, you have cases dealing with individual termination cases. That's what labor courts and industrial courts, today's situation, and this is not just in Bombay, but throughout the country, that's whatever I've heard from people. So there has been from a time when you used to have huge arguments, discussions, interactions, struggles on issues which are much broader than individual termination matters, you have come to a time when that's the only thing which is being discussed, you know. So that I can. Thanks. Now, why has this happened, and how do I look at it? See, the basic edifice and the entire edifice of labor legislation in India is, or anywhere for that matter, is premised on two underlying assumptions, which are obvious but need to be restated. The first assumption is that in the market of employment, the labor and capital are not the same, they are not equal. And therefore you need the intervention of the law to protect the workers. Because if you go only by the market of, only by contract law, then workers will never be protected. So you need the intervention of the law. The second thing is, even with the intervention of law, an individual worker and capital, the management, will never be equal, and therefore you need a collective force of workers to match the capital. Now, these are the two underpinning assumptions of labor law, around which the entire labor law has been. Now, these two major things, two major underlying assumptions, have been under attack since last 20-25 years. The earlier, I mean, it's true, very true that the labor law, as it is in India right now, only helps about 10% or 12% of the labor force. But while that is true, even in respect of the 10% or 12% of labor force, you're finding over the last 20-25 years, constant attack. And this is not just from the legislature. It's one aspect. Some amount of legislating has been done. But much more, according to me, from the judicial terrorism of the Supreme Court of India in the last 20 years. And this is what I just wanted to focus on, because you have had laws, even in the last 10 years, 15 years, okay, which are on paper protective of workmen, on paper giving certain benefits, giving certain rights. You have had the Manual Scavenging Act in 2013. You have had the Anti-Sexual Harassment Law, which is in 2014. You have had the Construction Workers Law. You have had the New Disability Act in 2015, which also talks about employment and protection in employment. You have had the Street Vendors Law. You have had the Unorganized Workers Benefit Scheme Law. So you have had laws in the last 15 years, especially in UPA 1 and 2, which on paper grant a number of additional rights to workers, which did not exist earlier. But the reality is, as earlier speakers have also spoken, have talked about, has nothing to do with the for instance, the Unorganized Workers Benefit Act is essentially schemes of benefit. It's not a rights-based law. It's a schemes of benefits. The street vendors law is again effectively amounting to throwing out a large number of street vendors and recognizing a few street vendors in a city. So you have had laws which, yes, on paper appear to be the Manual Scavenging Act. Despite the act being there every day, at least 10 people die in manual scavenging in this country. So, and these people have not been able to access the law, because to access the law, to access the justice system, you need unions. No individual takes the risk of going to court because that person knows that he or she will lose his job. So you need trade unions. And when there is attack on trade unionism, when the Trade Union Amendment Act came in 2001, where the requirement for forming trade union was made much more stringent. So you've had this kind of a situation where the ability of workers to come together to form a union has been whittled down quite a bit through the law. And in any event, despite the fact that formation of a trade union can be seen as a fundamental right, because right to associate is a fundamental right, the most difficult part for workers at a workplace is to get themselves form into a union, like the Maruti struggle case clearly told us about. The other thing I just wanted to, so this is the situation as far as legislation is concerned. I'll quickly just mention what I feel. Why did I say that there is a judicial terrorism in last 20-25 years? Supreme Court judicial terrorism. Let me make it very clear, because the other courts just follow the Supreme Court. Look at the situation for the formal working class I am talking about, or the organized working class. The situation before 1990s. I'll just give 3-4 examples and then stop at that. But and these are only illustrative examples. I can keep on giving 100 examples if you want, in terms of how the judiciary is complete. And that's where I slightly differ with Amita's executive summary, where she says that the trends of the judiciary depend on the bench. No, the trends of the judiciary depend on the decades in which that judiciary has been giving judgments. In the last 2.5 decades have been very, very bad for labor law. Take, for example, a situation where a large number of contract workers are employed by a company which also has permanent employees. The earlier law was that if you are doing permanent, if you are employed in a permanent job, then you cannot be treated as contract employees. And if the court says that you are actually doing permanent work, then you will be absorbed as permanent employees. Simple law. That law is changed to say everything else is fine, but if you are found to be working on permanent jobs and you are classified as contract employees, you will not have right to that job, but the employer will have to fill up fresh posts by appointing fresh employees. So if I am a contract employee, why the hell would I go to court saying that treat this post as permanent, but throw me out of job? Please, court, do that. Which contract employee will do that? This is one aspect. Second aspect, as I was saying earlier, the whole question of contract of employment. Now, the Supreme Court, in a series of judgments, including one famous judgment called Uma Devi, says that even if you work for 15 years, 20 years, 25 years, if your initial entry into the job was not as per procedure, you can be thrown out of the job. Okay? So ultimately, your contract of employment, which says that you are ad hoc or you are temporary, that will prevail over what your rights are in law. Third thing, in Balco's case, where the employees were opposing privatization of their company because they would have lost a lot of rights. It was a public company being privatized. The Supreme Court says that, sorry, workers have no right to have a say in any issue of privatization. Fourth thing, earlier it was believed, it was the jurisprudence of Indian courts that if while holding an inquiry against a worker, principles of natural justice are violated, okay, the worker has to be taken back on job. So, simple thing, that you can't violate principles of natural justice and throw out a worker. Now, they've changed this whole thing to say that, well, yes, but the worker will have to show prejudice has been caused to him by principles of justice being violated, principles of natural justice being violated. So you bring in what is known as a prejudice test. So if I am not paid subsistence allowance, if I am under suspension, I have to be paid 50% of my wages. If I am not paid that wages earlier, I would be taken back on job immediately by a court's order. Today, the court will show that because of that, you could not effectively represent yourself in the jobs. And the last thing, there was a famous case of 1977-78 called Bangalore Water Supply case, which provided that the Industrial Disputes Act is applicable to a large number of establishments which may not be traditionally classified as industries, such as educational institutions, hospitals, trusts, etc., etc. Now the Supreme Court feels that that is a wrong judgment, and therefore they have referred it to a larger bench. And if my guess is correct, and the way the trend of the Supreme Court is, they will overturn Bangalore Water Supply case. So a large number of workers, millions of workers throughout the country, will be thrown out of the purview of Industrial Disputes Act. Now, all these judgments have happened in the post-liberalization phase, post-1991 phase. Supreme Court is, of course, affected by that case. So, the trends of the judiciary, yes, you will have an occasional blip here and occasional blip there, which are good judgments, etc., etc. But if you see consistently, it needs to be studied how the Supreme Court has overturned its own jurisprudence over in the last 15-20 years concerning workers' rights, whatever limited rights they were. Okay? And that is something which I think we need to also look at very, very carefully about judicial trends, especially of the Supreme Court, because it percolates down to high courts and labor courts, etc. So that's all. Thank you very much.
Thank you very much for really showing us some of the issues that are happening in the courts, and the courts not really playing a helpful role in advancing the labour rights, which seems to be a rather disturbing situation. And also, to continue this discussion of the practice of labour law, I'm going to hand over to Mr. Raghu Kumar. Come on.
Thank you. I thank Nalsar University for inviting me for this session. I have 3 phases in my life. One is as a trade union leader for about a decade. Then management has picked me up and posted me as a law officer. For 10 years, I have to oppose the labor. And then I came out of the organization and became a lawyer, defending the rights of the labor. So these 3 phases have taught me so many lessons in my life. But basically, I would like to make 1 or 2 small issues. As a lawyer who is practicing in the lower courts, I have purposefully and with a categorical idea restricted myself to the labor courts at the trial level and the administrative tribunals at the lowest level, knowing pretty well that a lot of work has to be done in the high courts. I restrain myself going to the high courts. I need to tell you one fact out of my experience. The distinction between the organized labor and the unorganized labor has gone. It is no more available. And in most of the central, state and public sector units, employees are initially engaged on contract basis. Then they are subjected to a kind of probationary process after some time, and then they are regularized after almost of a decade or so. Central government departments are also following the same pattern. In my practice, I did one case of Central Institute of Public Plastic Engineering and Technology, where for the first time I have seen an agreement of appointment which says that the employee works as a trainee for 1 year, then becomes a contract worker for 2 years, and then if he successfully completes that status, becomes a probationary for 2 years. And in that case, what happened is, before he could complete his trainee period, he was identified as a acute kidney failure patient, and the management wanted to get rid of him somehow, because they did not want to maintain his medical expenditure. And suppose we were successful in securing the interest of the employee in the court of law, but it took almost 5 years for us to have the struggle. In my early period of my practice, because I was earlier a law officer, a trade union leader, a good number of casual laborers working in various departments have approached me, and I have dealt about 40 to 50 cases consisting of about, say, 100 to 150 casual laborers. The unfortunate situation is almost all the laborers got favorable judgments in the trial courts or the tribunals, and all are lying in under stay orders in the High Court since 2006-2007. It's almost more than 10 years or 11 years. We are unable to get those cases posted for final hearing, because in the High Court, we are now dealing with the cases of 2002-2003. So we are likely to get these cases for final hearing somewhere around 2020. And most of my clients have lost their hope on the cases. And in fact, as an advocate who entered as an advocate at the age of 45, now I'm at 58, I am also not so hopeful about my future as an advocate, whether I will be able to argue the cases in the High Court or not in the near future. These are all not one or two cases. Hundreds of cases are lying in the High Court. And in the meanwhile, a Supreme Court judgment of 2014 has declared that, because you know pretty well that the law relating to back wages is going on a change since 1998-99 onwards. Initially, they started saying that it is not automatic. What the judgments were saying that back wages, if the termination is found to be illegal, is not automatic. Subsequently, they have changed it as to you can quantify the back wages up to 50%. Now, the latest case law on that area is you need not give any back wages, you can give certain compensation. And that compensation in a particular case, Supreme Court has given as 4 lakhs. Unfortunately, it is treated as the upper limit for any case. And now the High Courts are granting only between 2 lakhs to 4 lakhs, whatever might be the case. And another ingredient in that area is, are you employed in a gainful employment during this period? I can never understand, I have argued before the courts as to how do you expect a man terminated out of his service to remain without employment all through when the case is being dealt by the courts. Naturally, a person has to go for economic activity. So you cannot say that even if the termination is found to be illegal, because of his gainful employment, this gainful employment concept has virtually taken away all the rights of back wages. And now, let me come to another area. I'm regularly in contact with various labor lawyers. Most of the labor lawyers are declaring that they do not want to practice in this area because they are disgusted. Nothing is happening. And in fact, we are feeding ourselves on the blood and sweat of the poor workers who are giving us fee by spending their, what's called, selling away their small properties or selling away their ornaments. So this is the kind of situation where morally most of the labor lawyers are feeling that they are doing an immoral act by defending them. Because by defending them, we are giving a false hope that after some time they are likely to get employment. In fact, that is not happening. And on contrary to that, ultimately we are succeeding even in the best of the best cases. We are able to get only some 2 lakhs to 3 lakhs compensation. And by that time, the worker might have spent more than that amount, or at least half of the amount, on the litigation. The entire labor law situation is in a total disarray in India. It is disrupted. There is nothing called as a labor law. All what we are doing in the name of academic discussion, as well as practitioners in the labor courts, is virtually what's called as an incorrect activity. There is nothing like labor law in India, either organized or unorganized. I am not even interested in distinguishing between organized and unorganized labor. Now, entire organized labor is joining the unorganized sector. It is not the question of uplifting the unorganized to organized. It is what is happening is we are getting down the organized to the unorganized section. So the most problematic area is practice, because all that what is available in the legislation is known to everybody. But unfortunately, I can definitely say that you cannot assure your client as a labor lawyer that you are likely to get a relief to him. It is technically impossible to assure any client because the lawyers themselves are losing the confidence. This is the situation, and in fact, I am very much thankful to all of you for calling me here. I am feeling immoral to be called myself as a labor lawyer. All of us are shifting slowly towards service law, which is a better area where the client can give some reasonable fee for us, because if we take a fee from the workers, terminated workers or other people, we feel guilty that we are doing some immoral act, and this is a very bad situation for the advocates in the labor courts. Thank you.
Thank you. Well, that sounds like quite a crisis situation when actually the lawyers lose faith in the very law that they are meant to give effect to. So there's a real challenge for the actual formal structures of the kind of traditional labor law, which don't seem to be working very well. Now we're going to get a bit of a comparative perspective from Professor Biju Mathew, who's been very involved in the taxi industry and unions in New York. So we look forward to your presentation.
Thank you, David, and thanks to all the previous presenters, and thanks to Amita and all the folks from Nalsar who put this conference together. It's a fascinating conversation, but also a depressing one. And part of what I want to think through in this panel and what's left of the conference is the question of, how do we pull ourselves back from this frame that we are in and ask some larger questions which can allow us to mount an offensive which is far greater than the offensives that we've been able to mount, given certain momentum, some inertia that comes from the fact that, we've been operating in certain frameworks of law, certain frameworks of, of the Constitution, etc., etc. Somehow I feel we need to find a way to break past some of these, and I'm going to try and ask the question how potentially one could do that. Let me start with the story, and the story is of on the 26th of January 2017, taxi drivers in New York City blocked up JFK airport for 6 hours in opposition to Donald Trump announcing all sorts of bans on immigrants, and as well as what's famously called the Muslim ban. Even as we executed the flash strike at JFK, Travis Kalanick, then CEO of Uber, announced that Uber was going to break the taxi strike by sending extra cars to JFK to pick up passengers. 45 minutes later, somebody started a hashtag called Delete Uber. And 300,000 people across the United States deleted the Uber app from their phones within the next 48 hours. That inaugurated an year of absolute disarray for the world's darling company, Uber. Sexual harassment cases, literally cases of espionage against the state, intellectual property right violation cases, the works, every single one of them have unfolded in the last 7 or 8 months. And for the first time, after starting a battle 4 years ago against Uber, our tiddly-biddly union, our small little taxi drivers union in New York City and in 6 other cities in the United States, which took on this fight against the $60 billion orangutan, finds that we have actually advanced our position, and we give ourselves a chance of winning something at this point. Now, I want to start the story in some part to respond to what everybody has said this far. I find every single presentation made on this panel, from Nikita's all the way to the last one made on the fact that there is no labor law left, to the concept of that, how should we rethink this notion of right to work? Should we move 2 steps back and approach it from the idea of a right to livelihood? Given all our experiences, including the ones recorded in the study, such as the fact that, for instance, there is a difference between procedural and substantive, and we are stuck with the procedural, and after that you get these stay orders, these injunctions that last for decades, etc., and the failures thereof. I want to start by telling a story that I sometimes feel is a little too celebrated. I sometimes feel is maybe just sheer luck on our part. The New York Taxi Workers Alliance right now has 19,000 taxi driver members in the city of New York. 85% of our budget, annual budget, is paid by our mass base. And we have no collective bargaining, we have no automatic dues checkoff, we have none of that. We've done this over a period of 20 years. Through a period of 20 years, we've done this out of sheer, I would say, just innovations of one sort or another. And every single penny of dues paid to the union today is paid voluntarily by the worker, not because of dues checkoff. Now, how did we get to this position? One of the most important things there, I feel, is that we stepped back from, we knew we were organizing independent contractors right from the word go. We knew we had no chance of getting any protections from the National Labor Relations Act, any act, the Fair Labor Standards Act, any act that did anything with the concept of employee and employer. We knew that from the word go in 1997, 20 years ago. And given that, we started innovating. And when I say we went on a flash strike in JFK, it's a kind of an innovation because we just took advantage of the fact that we are not covered by anything called collective bargaining, which would prevent us to have a strike while we're in the middle of a bargaining term, etc. And we use that and deploy that in the ways that we want to deploy it. Now, what we did, and this is the conceptual thinking that we did, and I think it very specifically connects to what Kamala said earlier in this panel, which is, we pulled back and we said, collective bargaining is a way of gathering power for the workers. So we don't abandon that idea of collective bargaining, that concept of collective bargaining. And the only question then is, how do we get to it as independent contractors? And what we decided to do was to put the state bang in the center, focus entirely on the city, forget about the ownership in the taxi industry, focused entirely on the city, went after the city, and forced a set of regulatory frameworks which created, in our opinion, a kind of collective bargaining issue wherein we would sit with the state, the owners would sit with the state, and the state had to come up with a negotiated agreement between the two of us. I'm not saying that this is ideal, but I'm saying that we reinvented some notions of collective bargaining as we went along. And it is this success, one after another. For instance, in the taxi industry, it's very simple. Every time the fare goes up, the lease goes up, and the driver gets shit. In 1997, when we started, we had a fare increase. The owners took 86% of the fare increase. The workers got 14%. In 2011, just before Uber came in, we had a fare increase, and the workers got all 100% of the fare increase. Through this whole idea of positioning the state in the middle, forcing the state, forcing more, the state is more subject to moral suasion than is the I don't know about the Supreme Court and its judicial terrorism anymore, but in that framework, we recreated collective bargaining. And even as we succeeded, got to this position in 2011 when we were an extremely strong union in New York City, Uber came smashing through. I'll spend the next 5 minutes talking about Uber, and then hopefully in a minute I'll conclude with some broader thoughts. And I want to start by saying we have Uber here in India, but we haven't seen the Uber business model in India yet. Here is the Uber business model. The Uber business model, as it operates in the United States right now, is if I have a car, a private car, something that I use to go to work every day and come back, for 2 hours in a day, 3 hours in a day, for 10 hours over the weekend, I can deploy that private car without any additional insurances, without any commercial license plates, without me going through any licensing procedure for being a taxi driver or a for-hire vehicle driver. I can deploy that as a taxi for any number of hours that I want to. What does this imply? First, this model is something that comes into place, and this is a model that is not limited to Uber. It's called the gig economy, the platform economy, where it's things like Mechanical Turk, TaskRabbit, all of these are part of the same framework, wherein it is the structure of this economy is based on the idea, especially in the West, especially in the United States, where for the past 40 years, from 1970 to today, we have a situation where the wage curve has flattened and gone down, and workers find themselves in a situation wherein they just cannot manage with a single job. So it's the second job, the third job, and Uber and TaskRabbit and all of these become platforms to get themselves a second and a third job. What's the impact of this? The impact of this is very simple, and I'll say it through numbers. Let's take a city like Los Angeles or San Francisco. In SF, at its peak, there are 3,000 taxis. On a Friday night when everybody's out drinking their guts out at bars, take a guess as to how many Uber, Lyft, and other TNC cars are out there, private plates. It's not 3,000, it's not 5,000, it's not 10,000. 25 to 30,000 cars on the street. The full-time workers who used to make the most amount of their money on that night, on those 2 weekend nights, go back home with $40 in their pocket. It's a race to the bottom of an unimaginable proportion through the part-timization of work. And this is the model. If you just look at the 11 cases filed against Uber in Indian courts right now, you can see that Uber is already testing this model by putting illegal cars on the street, etc., to test. It's not come because in India, the taxi industry is still developing in all cities except Bombay, which means that it's still in the growth phase, so it's full-time workers still here. This model of Uber, we have beaten back in New York. New York is the only place where they do not have part-time workers. Now, I say all this, And I want to pull back and I say that what is really happening, and I really agree that we really cannot go with these dichotomies or these continuums of organized to unorganized, etc. I think we really have to understand what capital with a capital C, is trying to do to the labor process. Marx framed the idea of the labor process as going through two changes, from formal subsumption to real subsumption. When you look at something like Uber, when you look at something like a lot of unorganized sector workers in India, we think it's formal subsumption. But with the kind of digital technology and the control that digital technology affords, what I think is really happening is a completely new form of labor subsumption that's beginning to emerge. I do not have the time to go into it, but I must say that I think one of the things that we really desperately need to do is step back, engage capital as theory once again, to come back at the question of creating a new imaginary for taking some of these things on. I don't think we can do it without doing that. I don't think we can do it at the level of what happens in what happens to individual workers, etc. I think we have to step back, look at just look at, everybody's been mentioning the last 25, 30 years. Capitalism as it emerged in the neoliberal period in 1990s, for instance, is not the same as it exists now. Uber is a company that has not made a single penny profit for 7 years now. Its total market capitalization is $18 billion. Its losses last year were $2.7 billion. Its losses in 2015 were $2.4 billion. Its losses between 2011 and 2014 were $5 billion. It's eaten up about 60% or 70% of the capital it's raised in its market, but its market evaluation still stays at $60 billion because venture capital is really pushing, because there's too much capital in the world seeking spaces of investment. What will happen to labor under such conditions? What will happen? I think we need to go back to a producerist logic. We need to go back to ask the question like the early labor movement, which looked at people working with their hands and said, how does this man, this mehnatkar, this person who puts effort, what do we need to do to protect him or her, and how do we create a larger framework which is all about dignity? Because the next panel, we are going into the question of the horizons of work, vanishing horizons of work. And again, it's a huge question. Will there be employment in the levels that we are talking about? And if we have to deal with that question, I think we need to shift the framework itself away from some of the nitty-gritty. I'm not saying we need to throw out all of the wisdom we've collected over the last 100 years of work. But I do believe that we do need to pull back a bit and ask the question, if collective bargaining is a concept that's come with us, and we know that that's a way to gather power in the framework of the social, yes, we take that idea with us, but we have to ask, what is collective bargaining all over again? Pull back, understand capital, and then come back at this whole thing all over again. Thank you.
Thank you very much, and also for telling us a bit of a positive story as well about work.
Speakers in these 2 days on land rights, on right to housing, etc. And all these are central to what I am going to speak about. Hannah Arendt thought of human beings as workers. And Rabindranath Tagore and Karl Marx thought of them as creative workers. So workers' rights are actually human rights. They are not distinguishable from any other rights at all. And if we have to think about the way the workers have been treated in this country, then we have to go back to the 18th century England, where you had, under the Black Acts, even petty thefts being punished with hanging. We really had no protection for workers until the Trade Unions Act of 1926 came in under the British government. The Factories Act had come in earlier on, but in fact they were quite ineffective because the power of capital was quite strong. In only Bombay there was some kind of collective bargaining. The first labor officer that was appointed in Bengal was a police officer, in fact, and his main role was to just beat down the workers so that they do not speak up. And the only time that the jute mill workers got any kind of relief from the extremely exploitative conditions under which they worked was around 1957 or so, when they were able to organize some unions. But even then, the managers, in fact, disregarded many of the acts because, first of all, as everybody has said, the capitalists have much more power than the workers. They could legislate much more. They could use gundas to beat down the workers. And furthermore, there are very few factory inspectors, and they had too much work to do. And some of them were easily bribed because they were badly paid. So even under the conditions after independence, the workers' situations were not really enviable in most of the states. In the public sector units, the workers had some protection because the state guaranteed certain kinds of provident fund, healthcare systems, etc. But in the private industries, even then, even the formal sector workers did not have very much security of jobs or any kind of healthcare provision, except for some exceptional groups like the Tata Group. But whatever the situation of the formal workers were up to about 1991, began to change after the neoliberal reforms. When the neoliberal reforms came, one of the first areas that they attacked was the labor laws that were there. The Industrial Disputes Act had provided for certain security of work for all organized workers, and it had been tightened in the 1970s to bring in more and more factories under its orbit. And the attempt of the state was to then pare down these laws so as to give capital more and more opportunity for dismissing, cowdowing, beating down the workers' wages, dismissing them at any notice and so on. And the flexibilization of labor that was carried out by the government was supported by also the economists who are following the neoliberal road. You see, the neoliberal road actually was started in Britain and in the United States under Margaret Thatcher and Ronald Reagan. One of the first things that Margaret Thatcher did was to beat down the workers. I talked to, I think, Walter Adams, what was his name? Chief Economic Advisor of Margaret Thatcher, and he said that the advice to her was to kick the workers until they are down and go on kicking them until they are further down. And Professor Bagchi is here. He had a long time back talked about the structural adjustment of the judiciary. What we have heard is the structural adjustment of the whole set of judges. The way the Supreme Court has cut down the workers' rights, whatever they were enjoyed. And the neoliberal economists have come in quite in a forceful fashion to support the government's attempts. There was a paper in 2004 in American Economic Review by Timothy Beasley and Robin Burgess, which claimed that in India, in the worker-friendly states, the productivity of workers was low, the rate of growth of workers of the manufacturing industry was low, and so on. Now, one of the glaring mistakes, you can easily see that they classed the Gujarat government as being worker-friendly. As reported by Mr. Mihir Desai, Professor Bagchi himself had found how the labor laws were being violated in Gujarat systematically. In fact, that was the situation from the word go there. In the birthplace of capitalism that Fernand Braudel had talked about, that is what they did from the very beginning. And then Aditya Bhattacharjee exposed the mistakes in these areas. in fact, Beasley and Burgess looked at only at the Industrial Disputes Act of the central government, and as has been reported, the central government itself has passed more than 60 laws relating to labor. And there are more laws relating to labor passed in the states, and in many states, these laws are even more worker unfriendly than in the central laws. You know, the Maruti case has been talked about by various speakers here. The Manesar case where the contract workers were in fact provoked to be violent, and on that excuse they dismissed hundreds of workers there. Now the Haryana government, instead of doing anything to protect the workers, in fact arrested most of the workers and threw them into jail. And this is also the situation in other states. Mr. Bridge Matthews has given us a hopeful idea that the taxi drivers in New York have been protected by organizing them into something like an union, but he has himself said that in other states of the United States they are not protected so much. In India, Uber has in fact been welcomed in all the states that I know. In Calcutta, in Delhi, in Bombay, I'm sure they have been welcomed also in Hyderabad. Because here the government really does not care about how much the taxi drivers get protection. All they care about is that they should work and more or less the passengers should be safe. And in West Bengal, the taxi drivers union is entirely controlled by the ruling party there. So there is no question of protecting them against the Uber's exploitation or anything like that. Now, the point that I have to make is that basically the only times that the workers have got protection is when the state has come in with strong measures of social insurance. For example, in Scandinavian countries from the 1930s onwards, they had given protection to the workers, and after the Second World War, partly because of the full employment situation that prevailed in most of the countries after the war, and partly because of the threat of communism from Eastern Europe, most of these states, whether they are ruled by Christian Democrats or Social Democrats, had adopted social insurance policies. And as soon as a situation came up from about 1971, when the rate of profit of the capitalists began to go down, then both the capitalists and the government went on a war path to beat down the workers. And as I said, the first governments which did that were the United States and Britain. In the United States, of course, there was no social protection for a very long time, but because of the full employment situation, they had enjoyed more or less reasonable wages. But since that time, practically from the end of the 1980s until now, the real wages of the bottom 50% of the workers in the United States has remained at the same level. Now, in order to prevent all this, while it is important for labor lawyers to go on fighting for the workers, and as both Mr. Mihir Desai and Mr. Raghu Kumar have said, that they are now despairing of practicing this course because the labor laws have been so pared down that there is no point in fighting for them. I think one of the things that I would suggest that the lawyers could do is to bring in the political economy aspect, that in fact it is the attack of capital on labor which is primarily responsible for the situation of laborers today, that they are not given the wages that are needed for minimum subsistence. Today, in the Indian case, the proportion of informal workers is 97%, and the proportion of formal workers is 3%. And even very few of the formal workers enjoy what the ILO calls decent work. Now, in order to guarantee decent work, there is no alternative now. I have seen heard many things against the state, but I do not know of any state in the whole world where without the state protecting the workers have got anything like a minimum subsistence. The one state that I can think of is South Korea, where from the very beginning the government wanted to shift the workers from agriculture to manufacturing, and they succeeded by adopting various strategies which India did not follow. I had one of the few persons who had worked on South Korea in the 1980s, and then the HRD ministry asked me, everybody as to who had worked on this area. I sent them my report, but they did nothing whatsoever. What they learned was from the United States, from Latin America, without learning. In fact, the members of the Narasimham committee, that Latin America under the neoliberal regime had gone through a utterly desperate situation throughout the 1980s when the growth rates had gone down to zero, and or in fact negative, and they did not recover in most of these countries until the middle of the 1980s. And with this kind of learning, with this kind of government, which is totally unfriendly to the workers, the only way to do something is to fight this kind of government, not just to fight the Supreme Court or fight cases, but you have to see that a more worker-friendly government has come in. I don't know how one does it, but this is the only way that we can go forward to protect the worker rights. Thank you very much.
Thank you very much to Professor Bagchi, and also for providing us with some of the historical context, how we've risen into the situation, and also some of the comparative material as well, and really laying out the kind of foundations of where we are at the moment. So we actually have thank you to all the panelists, firstly, for a fascinating discussion and presentations, and also being very disciplined. So we've actually enabled ourselves to have a good almost 35 minutes of discussion. I'm going to ask for a similar discipline from the audience as well, so not for very long comments, but to provide us with your inputs. I think we're going to really some of the foundational questions of modern economics and the interaction between economics and law, and of course we just keep in mind also the question of how we teach law. So without further ado, let's open up to hear your participation. Okay, yes. Yes.
I think fascinating presentations from all the presenters. I had a couple of questions. Of course, everybody can answer that, but I think to Kamala, of course, when talking of right to work and all, I felt that, like since we work with the homeless, and few of them are also into begging, by the way. And when we ask the people who beg as to who do they consider to be a beggar, the person's remark was, who does not want to work is a beggar. We want to work. Our work is illegalized. How can we work? So even at that level, people are wanting to work, So that's very important, that work brings dignity. And nobody enjoys begging as such. And in a country where all the municipality and everybody, they defeat you in every work that you're doing. So I think that's one thing, one realization we need to keep in mind. Two is, so for me, people into begging are actually battered workers. They've been battered, and circumstantially, they are left with nothing except to be outside temples or whatever. That's one. Two is, yesterday evening we had the street performers performing, right? And under the vagrancy laws, they can be hauled up as beggars and put behind bars. For us, they are the cultural workers and the creative workers that, Professor Bagchi was talking about. How is it? Because, and many of them, of course, if you ask them, it's work for them. And in our normal world of work, it's nothing actually. So I think, how do you see it? And the third is, the government has gone about demolishing much of this 46 central legislations into codes. When if codes are made, do you think the laws that you're talking about will be, how is going to be legislated as such? What are the challenges as such in the present scenario? Thank you.
Thank you. Okay, go ahead.
Is that me?
Yeah.
Thanks very much, David, and thank you to all of you too. They're fascinating presentations, and also from the other panels. I just want to make a quick comment and ask perhaps the lawyers for some enlightenment on this. The right to work, I think, is probably one of the rights that has suffered the greatest erosion. If you look at the enunciation, right to freely chosen work, and you look at the unfavorable conditions of the non-standard forms of employment now, there really is no correspondence. And my question on this is based on our reality in the committee. When we were working on this general comment on the right to just and favorable conditions of work, we very much tried to get trade unions and employee associations interested in contributing to the general comment. And unfortunately, we did not get much of a take-up even from the trade unions. So my question then is, perhaps could it be possible that the present situation of the insuccess in litigation comes from the fact that the right to work is still very much looked at in the tripartite framework of the ILO, and whether there would be any sense in moving it a little further into the human rights context where the interdependence and indivisibility could be argued at from a different standpoint. Of course, the committees are not courts, but they do have a role in adjudicating individual communications, and I wonder if that has been part of the thinking, that perhaps we could move away from this very strict tripartite approach into a broader human rights work approach. Thank you.
Great. Professor Bagchi?
I want to say two. One is to Mihir. I think judicial terrorism is a very strong word. And I remember my conversation in the 70s and 80s with people who called themselves industrial lawyers, not labor lawyers. I mentioned two, one or more, but giants, P.L. Malhotra and G.V. Pai, who were industrial lawyers for companies. And there were books from which we taught. Part of labor law. Kamala wasn't there, probably Kamala was already. They were in the forefront of, say, judicial terrorism. Workers' rights were, according to them, disproportionately and illegally awarded by the Supreme Court. So they found judicial terrorism as operating, court being pro worker. Now you are saying they are. So one question is why? How is two intelligent groups of society speak of judicial terrorism in two different ways? Now, very briefly, one answer is that one must, before talking about judicial changing its mind, look at why in the Supreme Court of India the right to property against all incursions by Parliament. 17 amendments and compensation, just compensation. It is undoubtedly to legitimate itself that the court invented the workers' rights. It is against its property jurisprudence considered bourgeois. They invented social jurisprudence to counterbalance. In the 80s and 90s, they turned, and it's my guess, they turned because a new generation of judges realized the charges of excess of judicial activism. And they wanted to practice social action litigation. So they turned themselves more to unorganized labor than to organized labor. But that's the first thing. The second thing I want to quickly say is, first is we have to realize why they changed. They changed as a fact, but why did they change? Second, very briefly, second is this question of teaching labor pedagogy is very important. And I think one way of doing it is to say, what did labor law contribute to the jurisprudence generally? And the first case we taught in administrative law was Krishnan case, which was a labor law case, which said rule of law must exercise power only for the purpose of which it is given. Purpose of which it is given. Thank you. I'm finished. So, what are the contributions labor law has made? The first human rights instrument was the Charter of Philadelphia, the tripartite agreement in 1920, ILO, before human rights were born. So there is a study of history is quite important for labor. What is the relationship? How do we trace the relationship between human rights and labor rights? I think first it came through ILO. So now Virginia is quite right that there are difficulties. Why? The question is why? Why is it that labor unions don't come before the committee and before the ILO? It's a very good question. Again, the answer lies in a different kind of labor pedagogy. Sorry for going on too long.
Okay, so we're going to... Okay, Professor Lipton, yeah, would you like to?
Thank you for fascinating presentations. I'd like to make one very brief point and ask a question. The brief point is that the position of labor does depend to some extent on what happens to world supply in labor markets. There has been an enormous explosion of the supply of labor in the world since about 1965, since the upturn in population growth caused by declining infant mortality started really to hit the labor force. So the world labor force expands at a great rate, and the supply of labor expands at a great rate. That is very unfavorable to the power of labor in the marketplace, very unfavorable to the power of trade unions. And so I agree with the people who've said that the residual activity of the state as a provider, not just of legislation, which will be ignored if the workers are weak and the bosses are strong, but of reserve employment in its own right is extremely important. And of course, shrinking the state as an employer makes this much worse. But the specific question I'd like to ask is about something I haven't heard today, surprisingly, in the context of the right to work in India, and that is the National Rural Employment Guarantee Scheme and its possible expansion and enlargement, especially since I gather it's been ruled that it has to pay at least the minimum wage, so that it cannot be a purely ultra-cheap employer undercutting the wage. If you have the state guaranteeing...
I'm not from the legal fraternity, but I've enjoyed everybody's presentation. I just want to highlight the issues of... I'm Ridula Bajaj, and I work with women and children largely, and therefore working conditions for women also. So we haven't touched much about female participation rates going down and why this is happening. And we do have labor laws here whereby special provisions are provided for women. Unfortunately, none of them are implemented. That's one issue. Why is female participation going down? The other is that the government itself has employed large numbers of women, and they call them volunteers. They do not give them any wages, our ICDS program, and they call it honoraria. They have unionized, but they are fighting a losing battle in the court. And the third is Manrega, again, where very clearly for every 5 children, there's supposed to be provision for a creche. It's been there on paper for the last 10 years. Not a single creche, no childcare support has been provided. How do we support women to carry on working during these reproductive ages? I think is a very, very critical point that we must take on board.
Great. So I'm going to ask the panel to give a few responses. If you haven't been addressed or you don't want to say anything, please don't speak so that we can get more questions. But if you do want to address something, please go for it. So who would you like to say anything?
I think one of the issues is, and I respond to the question on homeless beggars self-identifying as workers. One of the issues is, when I talked about work and livelihood, not necessarily as opposites, but that the work part does not usually capture people who are working for a livelihood. But there is a boundary. However much we stretch labor law, it cannot stretch beyond a point. And there are certain rights that flow out of citizenship, which clearly fall outside the domain of labor law. Now, street vending definitely, in my opinion, would fall within the labor law, loosely defined as people who have a right to earn their livelihood and therefore have right to public access to the public spaces on the streets, etc. And that should be seen as part of the labor law. And that's something that is growing, because that labor law is operating in an area where in India today, people don't want to do agricultural work. There's such a push to the cities. There's so much migration into the cities, and people who are able to do their livelihood and produce in economic terms, produce and contribute to the GDP, of course, are treated as part of labor law, because there is a classical understanding of what constitutes labor. But there is people beyond the point, people who are unable to support themselves. It is a fact that public assistance and social security have had their origins in labor law. Yet, I think in today's times, they have grown outside of it, and they stand outside of it. So, even whatever people may conceive, please don't take me wrong, but people who are unable to find work or provide for their own livelihood are going to fall into the broad social safety net of the state. And it's a difficult question where to classify them. But I think that there is that recognition that all forms of support cannot be rooted through labor law. There are some rights that flow. Well, citizenship is a difficult word to use because there's so much migration and they're displaced persons, but I'm using it as a placeholder where you still have to address the state and not necessarily either the employer. The other point that I thought I would like to respond to is on this question of whether the imagination of tripartism and whether the human rights framework is an adequate alternative framework or not. And I think that that ILO framework itself, of course, is so embedded in employment rather than work and rather than the right to obtain a decent livelihood, that it has its own limits. I think I'll just stop here.
Most of the panelists and also speakers talk about this informal working and outsourcing and other things. Right in front of the Supreme Court, underneath the Supreme Court, almost all majority of the drivers are engaged on outsourcing basis. The judges are engaging supportive staff on outsourcing basis. Supreme Court and all the courts are engaging the people on outsourcing basis. So if I argue a case before the judge, contending that this outsourcing is illegal, you are replacing the regular workers, what kind of response I am likely to get from the judge? See, these are all the what's called as practicalities of these things. One judge remarked when I was arguing a case of displacement of casual workers with outsourcing. He said, I am engaging outsourcing workers. Then I said about the law. He said, what law? How can I give a judgment in this area? 5 of our staff are recently engaged on outsourcing basis. We are calling for tenders. See, even the outsourcing is also not contractual under the Contract Labor Act. The outsourcing workers are not covered under the Contract Labor Act. Nothing like that. And the judges are saying that we are doing it every day. Supposing I argue a case of, say for example, the other area I tell you, like a dowry case. The judge was saying that yesterday I conducted the marriage of my daughter, paying about 40 lakhs as dowry. Where the question of my giving a judgment on that area? This is morality. The issue is I am trying to bring out everything is why we are unable to get these kind of things from the judges. And what happened between, for example, Sundarmuni's case has taken the termination issue to the logical extent. And ultimately, post Sundaramani case, they started retracting everything. Similarly, Bangalore Water Works case, it has practically, unwarrantedly expanded the definition of industry. It was not necessary.
Okay, thank you, Mr. Kumar. Did you want to say anything, Mr. Chair?
Just a couple of very, very quick points, starting with the first question on work and dignity. I think, I just want to put out two hypotheses and just invite you to think about it all over again. Not so much because I don't believe that work and dignity are connected very organically in today's world, but simply because I do think we need to once again free up our imagination there. So, what if I said that people are looking for dignity? It doesn't matter whether there's work in that framework or not, right? I think that's the first thing, because again, as we head towards a particular world where the surplus pool of labor and the nature of technology, machine learning, all of that comes in, I think we are looking at a very different world 50 years from now, 30 years from now, and therefore we shouldn't make the same mistakes we made in the last 30 years, which is get stuck with the previous model, which is Fordism, right? So I really think we can ask the question around dignity. We can say that work and dignity are deeply connected right now because of the hegemony of capital, which demands a particular kind of work. And I think we should not go too far in that connection of work and dignity simply because I think alienated work, while providing some notions of dignity because it makes you self-sufficient, certainly is not anything close to any ideal of dignified work. Right? So I think that's one very important thing to keep in mind. On the other question, I think several people, Professor Bagchi as well as others, about the tripartite ILO model, etc. I think that's one of the things that we really need to recognize, that we got stuck with an imaginary of the Fordist model, and we built a lot of our work in terms of our political work, in terms of our work towards protecting labor, etc., through that imaginary. And it's caught up with us. It was catching up with us already even during the peak of the Fordist period, because we really never had that kind of a Fordist model working here. And now that neoliberalism is coming smashing in, we are going to get, everything is going to keep falling apart. And so if we really have to pull ourselves out of this, I really feel that that's the reason why I'm asking for a new imaginary, to pull back, look at capital, look at how capital will organize itself over the next 30 years and try and build something new there.
Okay, so I'm going to give the other panelists a chance afterwards because I want to maximize participation. So I want to hear, I saw there were lots of questions, so we're going to try and collect the questions again. We are limited in time. So yes, the gentleman over there, but I'll try and take you all, but please, like a minute each.
Thank you so much. My name is Sharad Davla. Just two points I would like to make. Taking off from where Biju started, of innovation. Now we know that capital innovates and innovates quite rapidly. So when capital innovates, who is going to innovate on behalf of labor? That's really a big question. I think the positive note that he struck about this particular incident in New York, the spirit of collective bargaining, it's not the collective bargaining itself. Now, I think the panelists have really portrayed the scenario so well. I was quite surprised that there was no comment made on the trade union movement in the country. Now, who should innovate? Should we not actually expect the trade union movement in this country to have taken on that role? Though in India we cannot talk of one single trade union movement, it's quite fragmented. I think the bustle and the vibrancy that Mihir was talking about in Bombay at that time, that was generated a lot by the independent trade unions, factory-based trade unions in the multinational companies like Lever and Data Samant before that. So in the times that we live in, where trade union leader is no longer the hero, it's the entrepreneur who is the hero. Whereas the time that Mihir was talking about, trade union leader was the hero. Like Data Samant was the hero, and you can name it. That's one question. So I don't
think we're going to have chance for a second, because otherwise...
Okay, I'll just close with this one point. I can see that there has been a moral failure of the trade union movement itself. Probably it's the movement that has to bring in that spirit back.
Okay. And so if you're going to speak now, it's just a question, okay? Because we're just simply running out of time. So no comments, questions, okay? So I see people on the side. Okay, yeah.
My question is to the practitioners. I am Raghu Kumar, I teach the Tata Institute of Science. Are we seeking to, and this is particularly to the lawyers, Mihir Desai, and not just lawyers, but Mathew as well. I think this is a certain dismissal of the space of law that I've heard in the presentation. I'm trying to address that partially also with Nikita's presentation. Are we dispensing with this idea that within the Bagchi spoke about the complementary unity of law, that yes, it legitimizes class power, but it's also something which allows for questioning the borders of the state, questioning the state itself. And that complementary unity of law exists, that possibility exists, but somehow I see a certain dismissal in the space of law, and are we therefore willing to address this, how this shift has happened? You had the Asian case in 1983, which also provided a normative basis for the right to work and so on, which, I wonder why Saurabh looked at the ICSCR as the normative basis for the right to work in 2006.
Okay, thank you. Thank you very much. Yes, behind you, yes.
Hi, I'm Kritika from Bangalore. My question is to Ms. Saurabh. While talking about the meaning of right to work under ICSCR, it was stated that right to work is a universal right. So talking in this context, where do we place children? How do we work with the nuances between right to work of children and the issue of child labor? Thank you.
Okay, great. And then we had a question over there.
Thanks for a wonderful panel. Just to keep it short, I just had a question where I was wondering if some of the panelists builds from some of what Professor Kamala, Sankaran and Professor Biju, Mathew talked about, is whether you think that the right to work in can be or needs to be partly reformulated in relation to what we discussed yesterday in the other panel about city, especially because Indian context, particularly we see, but this is true with like New York and the taxi drivers as well, is that a lot of work is linked to access and right to public spaces, which we know in the liberalization period have been shifting, the way in which those are sort of regulated, etc., and also the right to housing. So if you think about home-based workers, large section with women working in that, you think about waste pickers and their work of not only on the streets but also in the homes of waste sorting. So there are a number of, besides the street vendors who have been touched upon, there are a number of other occupations out there. And so question.
Thank you. And there was someone over there, and then we'll come to the side. Okay.
When we're dealing with labor law, one of the areas this panel did not really address was the issue of law which was already existing for so-called unorganized, like the BD worker, and how formalization took place for many sectors like port and dock workers, and which is what the construction workers also were aiming to do. And these were labor legislation which were treated, they asked for regulation and they got welfare. So these were the kind of problems that rose in the 1990s and 2000s. So, I'm going to move to, again, domestic work, where a single woman does not get covered by law in India. So how do we look beyond the minimum establishment and those kind of requirements in Indian labor law, and how do we move forward for that?
Okay. Thank you. And thereafter.
My question is to Vasanthi ma'am. You distinguish between sentience and human rights. So how would you look at the context of circus industry, animal performers, which is where these two, the idea of sentience and human rights actually clash quite significantly? Thank you.
Okay, and there were two questions over there.
Just a question to Professor Kamala Sankaran. You seem to devalue.
Okay, let's go on then. Okay,
good. You seem to devalue the organized sector too much. In the sense, it's true that it's a very small proportion of the workers, but isn't it time to innovate? Because as Mihir Desai said, no individual worker can really survive. We need collective bargaining. So isn't it time we use the techniques, innovated the techniques of work earlier, techniques of organization, to organize the unorganized sector and see the possibilities of collective bargaining there as a part of their right to earn a living, not just salary and working conditions.
Okay, and last, Professor Steve.
Thank you. I have two quick.
Quick.
Isn't it all possible to think about lawyering for workers similar to public defenders? I mean, you pointed out to a very deep conflict of interest here that causes the profession to decline, and there are similar issues in other basic rights, so is it at all possible to think about it? And my other question is to Professor Sankaran and Vasanthi about maybe thinking about formulating a new topic, because at my university we've been experimenting with declassifying certain issues and reformulating the topic, and just focus on the law on livelihood, employment and public assistance and administration and criminal nuisance law and wrapped up and the freedom. So I think it's to redefine what the topic.
Okay, great. So thank you very much for the questions. We're going to now go to the panelists who haven't had a chance to have a brief 1-minute intervention each. Okay. You don't want to? Okay, great. Go for it. Okay. Switch on.
One is that it is true that now the rate of growth of workers has escalated enormously. But you see, in the case of India, we did not try to educate our people so that they could control their rate of birth themselves voluntarily, as was done in China. I mean, we are forgetting that during Maoist time, the rate of, let us say, the per capita income of Chinese was low, but there was full employment throughout. When Deng came in, there was already full employment in China. And of course, after that, there has been a systematic attempt to shift workers from agriculture to industry, and China has more or less full employment now. We never attempted that. So that is one problem with the rate of population growth we had. India had, after all, a much lower population than China at the beginning. And the second point is that in the case of trade unions, AITUC was dominated primarily by leftists at the time of independence. So Nehru, in order to diminish that domination, split the trade unions at that time and created the INTUC. And from the very beginning, Nehru's primary aim was to industrialize India and control the laborers. So from that time onward, in fact, laborers were controlled in order that no industrialization drive could be face any obstacles. So from that time onward, we have had problems with even formal level workers, and as I said, these problems have escalated after that. And the global situation has also affected the Indian judges' opinion and the opinion of the politicians. They have been very much influenced by what has gone on in the United States and in the world of neoclassical economics.
Thank you. Professor Desai.
Okay. Only two quick comments in the time I have. I don't mean to say that labor law practitioners should stop practicing or new people should not come into labor law. I want them to come into labor law. I would, but that is a question which I would ask people who are professors of law as to how many of their students are seeing labor law practicing as an option, as a career option. I think if the answer is even one, I would be very happy. That's the reality of today, which is contrary to what it was 30 years back. And the second thing which I just wanted to respond, I think maybe the term judicial terrorism is a very strong term, but what I see is after 91, there has been a complete and consistent dismantling of the labor law edifice, the judicial interpretation of labor law, which had been established before that. Possibly it has something to do with partly individual judges who are Chinnappa Reddy and Mihir Desai would give a different version from say Pasayat. So that's one way of looking at it. The other is, of course, the whole neoliberal consciousness that workers are pampered and they need to be put in their place has gone into the heads of the judges very, very deeply. These are the two things I wanted.
Okay, and then Professor Vasanthi, you don't want to, you're okay with not having you waiving your right now. So I want to give the last words to the actual project, and you've heard a lot of things. Would you like to say anything, Mr. Bhattacharjee and Ms. Agarwal, if you would like to say briefly, a minute each?
Right, with respect to the specific query on child labor, I think our starting point has been what ILO calls as decent work, and right to work would imply right to non-exploitative work, and from that angle, child labor would not fall within non-exploitative work at all. As far as the PUTR case goes, we did mention that right to dignified conditions of work has been recognized within Part 3 of the Constitution. But we felt that ICSCR may be a better vantage point to start with, because it clarifies the different dimensions of work. And one of the problems we have encountered with India there is a lack of clarity on what is often seen from very general response to very technical parts of actually wrong. So when you compare that with the clarity that Janardhan provides on the because that allows us to get a better grip on what I do. On the other point that we brought up, I think it's very important to address the question of agency as well, because the agency has been defined in our statutes, which include several other informal forms of work. And I think one of the points that perhaps we did not capture enough in my presentation, because I do work also includes freedom of work. And perhaps the next session touches upon this in much better way. The way in which state has criminalized and put under severe regulatory restriction many forms of informal livelihood. And I think the point Dr. Sankaran made about livelihood as being a part of right to work is something that captures that element in a very strong manner. On the issue of human rights and labor rights, I'd like to draw upon writings of Guy Davidoff and Kevin Colvin, and they have often brought out the point of how rights are often a counter-majoritarian instrument. And between 45 to 1991, where unions were at ascendance, or you had fair degree of resonance about workers' rights within the political and legislative constituencies, then perhaps the need to resort to human rights was not as acute as it's now when labor rights are under a systematic assault. And I think the point that Professor Bagchi also emphasized on, if labor unions have been dominated by groups from the left of the spectrum, we have to be honest that there's been fair degree of suspicion about the human rights agenda also, largely because of the old hierarchy of civil, political, and socio-economic rights. So I think that's also one of the points that explains the divergence between human rights and labor rights agenda that often we have encountered, even though labor rights were probably one of the first major instruments on human rights at the international level. Thank you.
Thank you. And Ms. Agarwal, do you want to have a brief comment?
I want to speak about one comment on the question around the innovation of I feel like the question around who is innovating on behalf of labor is the answer is fairly simple. It's laborers, it's the workers themselves. And I think the Bharti example of coming into play was for me an excellent example of workers from within the jail. Activities and the elections, union activities, and have still been very influential in the way the management is bargaining with the workers.
Thank you very much. Last week I was, let's give a round of applause to our panelists. Last week I was